now? Yes, thank you. I'm sorry we're speaking through these, but it's for the audience that's not here, because I'm sure you could all hear us and we wouldn't need to do that. I'm Stephen Franks. I've been on the Council of Free Speech Union since it was the Free Speech Coalition. We, as you probably most of you know, we formed spontaneously around Phil Goff announcing that he was going to make sure there would not be what he called divisive views expressed in Auckland public facilities. And as so often happens in life, accident meant that the group of us who formed interested in that issue and then decided that it was a cause that had to carry on, particularly because the court process took so long, have now become elders, and we're trying to replace ourselves. But I thought would be useful for people interested in the legal issues to throw if I call them legal bones to the experts on the kinds of issues that trouble us on the council, because there are quite often multiple views or divided views on whether we should be taking up a particular issue, how hard we should take it up. In other words, you can put a lot of energy in, or you can make a statement of principle because you have to, but actually not try and spend too much time on it, because you can lose a lot more support than you gain on some contentious issues. We feel that when there is a principle at stake, we have to make the statement of principle, but there's a big difference between making a statement and spending $20,000 or $30,000 and campaigning. So this is most of the issues that I'll throw out will be of that kind, and then I've been asked to make sure that we leave at least half the time for comments and questions from you people, so that it's a discussion amongst us. I certainly don't intend to try and introduce Lord Sumption. You've had that introduction, and as was said by Jonathan when we came, on my immediate left is the man regarded as the premier scholar on our constitutional and administrative arrangements. I had a recent employee interview where the employee came to New Zealand only 10 years ago from Russia, and we've taken her on incidentally, but she said, I really want to move into the administrative law. I have read Philip Joseph from cover to cover 3 times. I don't think there'll be anyone in New Zealand who'll have done that. And Lady Deborah Chambers, your support of a range of let's call them liberal or Enlightenment value positions has been long-standing. I was keen to meet you to find out a little bit more about the Zowie case and what drew him back to put himself at risk again. But because I think you'd probably be as close to, or would have been.
No, that's not me.
It's not you.
Deborah.
Deborah Manning. Oh, sorry, it was Deborah Manning. Oh, okay. I apologise.
So I can't answer that.
So, start this first one. I'll mention one that's very topical for us. We've discussed it, or someone discussed it, raised it in the last one. The big march that's threatened to try and disrupt the Remembrance Day commemoration in London. One of our leading cases in the free speech area is a case called Morse, where the Court of Appeal eventually held that flag burning was an act of free expression despite a specific act in New Zealand. The Supreme Court got to that. Supreme Court but despite an act that forbade the desecration of the flag, and that act had been attempted, or in fact they'd done the act at an Anzac Day ceremony in the midst of the Anzac Day crowd. And I was very close to it because my wife was about 5 metres from where they did it, and as the daughter of a military family, I thought that she was going to be violent. I was holding her back. I think I was an MP at the time and saying, no, stay. But the court managed to find that was a protected act of free expression despite the contrary law, and it's always seemed a problem to me. I've always thought that there was room to develop some kind of distinction between the free speech that leads to reason, or that seeks to reason and to persuade and to inform, and the speech which is essentially designed to inflame in a particularly delicate situation. I think you were asked about the Remembrance Day issue, Lord Sumption, and you've given our comments. What's your view on the Morse judgment, Philip?
Well, I think you mentioned two cases there. There's Hopkinson in the Court of Appeal. That was flag burning as well. And then the Morse case in the Supreme Court. And they upheld, eventually, the right to symbolic free speech there by setting alight to the New Zealand flag as a protest against New Zealand's involvement in so many theatres of war over the last 100 years. So they were actually decisions to be commended, and I think the Hopkinson case in particular went against existing authority under the Bill of Rights Act to uphold that. So they are commendable decisions, but of course the Supreme Court treats each case on its own facts, and I actually happen to be involved with one representing the Free Speech Union, which we might come on to, the Moncrief Spittle case. That was under the rubric of the heckler's veto, where you get unsubstantiated threats of blockade and violence because certain groups don't like what others might want to say. Well, actually, we went to the Supreme Court on that, and my learned friend Jack Hodder KC and I lost 5-0 on that, so it wasn't a great outcome. We were intensely disappointed, but not necessarily surprised in the environment in which we operate today. And I just referred back to what Lord Sumption was saying. I thought it was very pertinent when he said that, in fact, many of the forces of closure, if you like, or cancellation, are from the young today. Of course, the young, when I was young, which was so many years ago, I can scarcely remember, but the young were there to challenge the status quo. Well, now they impose their own strict edicts on what can be said and what can't. So that's a very interesting development, and that was with Peace Auckland Action Group that was threatening the blockade and Moncrief Spittle, but we might come back to them. I've probably said enough.
Actually, Valerie Morse.
Yes, well, Valerie Morse, this is the irony, the leading case is Morse, and then the Supreme Court finally upheld her right to burn the New Zealand flag at the Anzac Day ceremony, and that same person, she actually made the unsubstantiated threat of blockade to the two alt-right Canadian speakers, which caused Auckland City Council to cancel the venue without any investigation, and for some reason the Supreme Court upheld that decision, but professional convention says that I can't bag the decision. I can be bitter, but I can't bag it.
Lady Chambers.
I'm not so sure about the convention that you refer to of not bagging decisions. I think the legal profession, are too deferring to judicial attitudes, judicial approach and judicial work. And I speak as someone who was married to a judge on our Supreme Court, so I'm familiar with being inside that pond. And I think that there needs to be, in fact, a new attitude there too, where there is far less deferring, and I mean, there's much chatter at the bar, which is critical of the Supreme Court, but you will not see it published because we are aware we will need to appear in front of their honours, and we're nervous of saying anything. And I think actually academia has a very important role, because they are less likely to be working advocates, and I think that they should not hesitate to be critical of decisions. I think, just while I'm on this, can I just mention one other thing? The most glaring example was our response to COVID, because I feel that, in my view, the judiciary and our legal profession let us down badly. So did other institutions. And the problem is that when they let us down that badly, we know that the public opinions show a shift of lack of confidence in our institutions, in our media, in our politicians, in our judicial and legal system. And that is dangerous. that is worrying, because those institutions are so vital for our democracy. When we look at how the courts responded, and my profession responded to COVID, we were weak. And part of that was that it was hard to organise in lockdown. You'd hear cases and you'd say, well, I'll do it, bring them to me. We had a couple of little cases with people allowed out of quarantine to see dying relatives. We had one case which said, the Court of Appeal said the first 8 days of lockdown were illegal. Well, whippity-do. And then we had this appalling case where a group of New Zealanders went to the Wellington High Court to say that the locking out of New Zealanders from their country was contrary to the Bill of Rights. Now, if that was contrary to the Bill of Rights, and Her Honour did eventually find that it was contrary to our Bill of Rights, it was the biggest breach of the Bill of Rights that has ever happened. It did not get priority. It was slow. There were much of the talk at the bar was that the Crown didn't want to give discovery because in the Crown's discovery were opinions by Crown law saying that the system of not allowing New Zealanders back into the country was contrary to the Bill of Rights, and yet the judge continued to give adjournments to the Crown. It went on and on and on and on, and it was finally released in April after that system had been dismantled, that it was a breach of the Bill of Rights. Almost useless, hopeless. And so I think when I look back at how that happened and how disappointed I was with not just the judges, also my own profession, that we didn't take more steps when those breaches were, that those very significant breaches of the Bill of Rights were occurring. I have to say that I rather lost confidence myself in our ability to respond. And as a result, I do think that J.S. Mills was right. We need to speak out more. We really need to speak out more.
Could I just add to that before this next question that when I wear my academics hat, I don't hold back. Only when I actually appear in court, I've got to, I think, show a degree of decorum or restraint. That's all. Totally. The second thing is I really endorse your comments regarding the judicial response to COVID. If we could talk about the Borrowdale case, that was the one that challenged the legality of the lockdown itself. Now, for the first 9 days, it was held indeed to be unlawful. But the entire duration of that lockdown, in my view, was quite unlawful. But the full court of the High Court contrived a means under the Health Act of 1956 to say that the actual lockdown was a valid exercise of powers under that Act, when in fact there's no way, reading that Act objectively, you could actually stretch it that far. But, you know, in the third paragraph of the decision, it was a long judgment, there was a statement saying what a wonderful job this government's doing of containing COVID and looking after its citizens. Well, any pretense at judicial neutrality was just thrown out the window. So that's, I endorse your comments completely. But when I'm acting as an academic, I don't hold back.
I'll just say I have the good fortune of not having to be a peer, but my colleagues and the barristers we instruct have the bad fortune of me feeling unconstrained. And a number of my friends and former partners are in senior courts. I think they should be deeply ashamed of themselves. I think the judiciary of this country is rapidly becoming our version of the priesthood. Mainstream religion's lost its power, and the people who would have been priests always seeking out sin and combining to shut them out have now moved into our profession, and the courts are extremely unreliable. I cannot often predict the outcome of applications where the law is tolerably plain, and of course you've probably seen one very recently, which is not in the free speech area. I think that practicing lawyers will all have different ways of talking about it, but I think it's a loss of cultural confidence, and I see it as searching around to avoid being on the wrong end of the cancel item.
lawyers of this country be afraid and be coerced by the so-called government?
I don't. It's self-coercion. But Lord Sumption, it might be easier if we asked you if you had a view on the cultural element of judicial practice.
I've never heard of this convention, and I don't think there's any such convention in England. If there was such a convention in England, I think I broke it rather too often. I remember sitting
drawn, say, from competition law, where there are bottleneck facilities in the marketplace of ideas, where you draw perhaps from the common law, the way it developed the special rules around common carriers. They had privileges and they had responsibilities. Should we be more bold in saying that Twitter and Facebook and the NZME organs, because of their dominance, clear market dominance, should be obliged to carry stuff or not to suppress certain lines of argument?
Stephen, am I able to say something before we move too far away from criticising judges? I would very much like to criticise judicial activism since the 1970s, in particular the work of Robin Cook and Geoffrey Palmer. Their political they were judicial decisions, but they were strongly influenced, and they became the basis of the conformity to treatyist ideology. I'm thinking particularly of the judgment that the treaty is akin to a partnership. And yet they are not called to account. I've written a number of articles where I have criticised the judicial activism. But where are judges talking about this, saying that where is the point where we stick to our knitting and we get involved in politics to the point that because we are now the secular priesthood, that what we say is taken as, the word. The world is translated into the word by the secular priesthood that we have today. So I would really like to see a lot of criticism of the judges in this country and the role that they have played in installing the culture of ideological conformity that people seem unable to break through, because it's at the level of faith.
You've seen some of it here. By legal propriety standards, our panellists have been outspoken. But do you want to comment on the idea of extending free speech obligations, upholding free speech obligations on to the dominant channels?
Well, I was just about to ask, could you give a definition of judicial activism? Because I find it a troublesome phrase. I know that Robin Cook replied to that allegation of judicial activism by saying, well, judges don't activate anything, they just hear the cases that come before them. They're quite reactive. But I think I know what you're suggesting, if you'd like to give a bit of a definition.
That was really a cop-out, because what he said played a major role in establishing this culture of conformity, which is which completely covers this country now. It's not enough to say, oh, I did this, I made this decision, but hey, I only meant it for this environment, when it has taken off. It's a bit like, with one's academic work. When you write something, you have to live with the consequences of it, even if you didn't mean those consequences to happen. My own work, for example, the consequences for me are that I'm described as a right-wing racist. I have to live with those consequences, and I have to address them. And I think that Geoffrey Palmer should have addressed the consequences of his judicial decisions.
He's not a judge. He's never been a judge.
As a lawyer. I think of Robin Cook. Robin Cook. And Geoffrey Palmer, as a lawyer, once he became a politician, I think he should have talked openly about that relationship between legal decisions and politics. That's what I'd like to see, you know, that discussion of to what extent are legal decisions part of creating the culture, including the culture of free speech or the repression of speech, which is really what we've seen in this country for a number of decades.
To be fair to the judges, it was Parliament that used the phrase principles of the treaty, and it used it repeatedly, and partnership emerged as essentially from an invitation. The judges can't treat statute as if it doesn't mean anything. There were no principles, so they had to invent them. And I'm afraid some of them have been very enthusiastic and welcomed the opportunity, and they're continually evolving. But it was Parliament's fault, and the senior ministers at the time know that. I had David Longy tell me to three of us in the middle of a big dispute, you're right about Geoffrey's responsibility. Geoffrey told me that wouldn't mean anything. He said it was just a diplomatic phrase. It would mean nothing. So there was a major legal stuff up there, and but we can't blame the courts for trying to give meaning to dumb phrases. We've now got a whole category of law writing that does it. The Marine and Coastal Areas Act is full of undefined terms which the judges have just defined in a way that's thrown petrol onto the fire.
Yes, I think that phrase partnership was used in legislation before the Robin Cook decision. And I do think one of the principles is that judges are not elected and they are an elite. So, I mean, they must make law to some extent just by interpreting legislation. But they must be careful because they're not elected and they are an elite that views the world a certain way. So, but Stephen, just to pick up your point, are you suggesting that there is some kind of legislation which says that social media is also required to present balance when issues are raised in the same way that the mainstream press is? Is that what you're suggesting?
It's not really articulated because we're nervous about it, and we've ducked a number of serious issues. But it comes up not just with media, it comes up, for example, with denial of what you might call essential services like banking. There have been some cause groups who've been debanked in New Zealand. The Nigel Farage experience is not unique to the UK. And there's been threats that more of them will be. And we've thought, is it right for us to say that this is happening as it is because of their people's expression of view? Do we treat this in the same way as we've treated some major employers who have sacked or tried to sack employees because their views are unwelcome or unpopular with some section of their staff, or allegedly unpopular? Once we get away from the state exercising its power into private individuals, it gets quite difficult for those of us who think that people should be allowed to discriminate. It's one of the rights that you have as an individual to discriminate, unless the law has made it prohibited, and even there I think it shouldn't have intervened. But it's a troublesome issue for us, and if people in the audience have got views on where we should be going, don't hesitate to express them.
About the area, judges becoming moving into the area of politics and the area of law, and as soon as they, obviously it's a grey area, but it's something that you warned against quite extensively, and we're seeing the effects in this country.
Well, that's exactly right. Although since those lectures were delivered, there's been a significant change of mood in the Supreme Court of the United Kingdom, which has issued 2 landmark judgments restraining the enthusiasm of the courts, particularly in the area of human rights, from embarking on a development of the law which essentially cuts across lines of responsibility which ministers owe to Parliament rather than to the courts. So the situation is better now than it was when I delivered those lectures.
Just a question.
Does the Law Society, and I'd be interested to hear Lord Sumption's opinion too, have an opinion on what could be deemed to be unethical behaviour on the part of the Medical Council of New Zealand towards its doctors over the last few years who have sought to express their right to freedom of speech regarding legislation such as the Bill of Rights, the Health and Disability Code 6 and 7 regarding informed consent, and also the precautionary principle in regards to the medical procedure of vaccination, or the Pfizer in particular injection, and the abrogation of those rights, and what informed consent actually required. And these doctors have been vilified, suspended, and forced to pay, some of them $120 an hour, to be re-educated at the moment when they speak on social media and how they speak on social media. What are your opinions on that? Because I haven't really heard anybody standing up for the medical profession, and they're very brave people, the ones who have spoken out, and there are plenty that wanted to who haven't. So do you have an opinion on how that could be approached, or how that's come to be? Because it seems to me rather tragic that the Medical Council almost have gone above the law and ignored the legislation, and I'm not sure why. But I'd be interested to hear your opinion on that, and what we can do perhaps to address that so it never, ever happens again. Thank you.
I don't think the Law Society has any particular responsibility to comment on the behaviour of the medical regulators. Certainly they wouldn't be regarded as having such a responsibility where I come from. There is a danger that some professional organisations may expand the scope of the rather loose provisions about discrediting the profession so as to try and suppress things that opinions that other people wouldn't like. But certainly in Britain that has not been a big problem so far.
Either of you want to comment?
Yeah, the Law Society has got no jurisdiction over, no remit with regard to the medical profession. I mean, it's only there to regulate and discipline its own, lawyers. But you said that the Medical Council, or this particular disciplinary body, is actually ignoring its own statute. Well, it's just screaming out for a challenge by way of judicial review, because that's a publicly functioning body which is subject to the Bill of Rights Act, for a start. And so it seems a little bit odd that, in fact, given the consequences of the decisions it's handing down, particularly with regard to mandates and losing one's employment, that why hasn't this body been challenged? I mean, that's a question I put to you. I don't know.
I think we can answer the Free Speech Union. Roderick, you might want to comment. I think we've got 3 active cases at the moment, or 2 active cases, and we've had others involving medical people, and the statute and the rules that they're operating under give them a lot of cover for basically making it up as they go along. Is that a fair summary, Roderick?
That's a very good point. I'm Roderick Mulligan. I'm the chairman of the Free Speech Union. I'm also a practicing doctor. What we have discovered when approached by several health professionals who have fallen foul of their professional bodies by dint of expressing opinions on things like vaccines and other topics that are not currently popular with the mainstream, is that we take them on and we represent them. But the disciplinary bodies whose job is to adjudicate on these things are generally looking for things like expressions of remorse and an offer to reflect in order to retain your practicing certificate. And that's not really what we're looking for. What we're looking for is an endorsement that your professional obligation is to things like giving your patient informed advice. We've got one that we're likely to take on where the patient actually wanted I'm struggling to think of the name. What's that drug that everybody, the fringe people say treats the COVID? Ivermectin. So the patient actually said, I'd like some ivermectin. And the doctor was sympathetic. And so this was totally informed consent. It was outside mainstream practice, but it was informed consent. And the doctor who prescribed it subsequently fell foul of the medical council. That is absolutely not their role. And I think we do have an issue that these disciplinary committees are captured by the same sort of thinking. And the disciplinary committees are not legally robust. They're generally not legally qualified, and they generally operate on the basis of feel-good principles. And if people have hurty feelings, then there must be a problem with your practice, and this sort of thing. So I think it's true that we are heading for a judicial review, with at least one of them. But my concern comes back to what has already been canvassed in this panel, that the courts are not as reliable as they should be for saying what the law is. Now, if we took a judicial review, we ought to have some confidence that the Bill of Rights says you have the right to these freedoms, you have the right to impart information, and if the profession puts a gloss on that you have to give a patient proper informed consent, and if you're expressing a minority opinion, you have to say that you're expressing a minority opinion. But as long as you've done that, you're within the law. You should have some confidence that that's the position a judge would take. I don't have that confidence. I think there's every chance that if we rocked up to a High Court judge, we would find a judge trying to agree with the system, to agree with the establishment, to agree with the status quo, to agree with the right of these committees to sort of knock people back into line for the sake of the greater good.
There's two interests. When we're acting in these cases, we often have to remember the interests of the person who's come to us. And we won't necessarily have $100,000 to throw at it. They don't have a whole lot of time. And often they come to a point where someone offers them, if they make a ritual apology and remorse and go along and do some retraining, go through a struggle session, we can't say don't do it because that's in their interest, but the case goes away. But there is a very helpful case, recent decision, the Sue Gray case, where Sue expresses her views on a lot of things that I think are quite nutty. But the decision was robust, that the disciplinary tribunal should leave her alone. She was expressing her views and she hadn't crossed the boundary. So in terms of at least one professional body, the Law Society, we do have a very helpful recent decision in her favour. We're a small country. It was a good reason. While we had the Privy Council, we could get stuff out of this little hothouse. Now we don't.
Kia ora koutou. My name is Sandy. I've come from Palmy, Vegas for this event, so clearly the centre of the universe. Thank you for being here. I think we're headed into a really interesting territory with our election, and I want to know what you think about free speech-wise and legally-wise, if we go into what David Seymour would like to do and have a referendum about, I think he talks about the principles of the treaty. In my day jobs, I'm a professional listener, I'm a chaplain in healthcare and a restorative justice facilitator. I know how hard it is for people to actually give voice to what they really think. All of the people in this room are probably quite articulate, but the people that I often deal with are people who might have strong opinions, but often don't know how to express them that well, and sometimes they come out wrong. And we're in a situation where I think lots of people would like to express opinions, but they might come out wrong. How are we going to manage this in our society, legally and in a free speech way, so that we all can say what matters, but not kill each other in the process, if you see what I mean? I would really value your input.
Pass.
Well, for myself, I'm feeling more optimistic about these issues. I doubt very much if there will be a referendum. But what I do see is an increasing acknowledgement by much of the mainstream media that we need to have an open debate. We need to have a discussion about the treaty and the founding document and issues in regard to how Māori and Pākehā get on in this country. And that is clearly coming through now. And I think that's a great thing. And I think we do need to have that discussion. And I think in some ways that battle has been won now, and things will get better in that space. And I think we need to be able to talk to each other about our views without people becoming defensive and so on before we become, in order to stop this polarisation. So I think we are going into a new stage of our constitutional culture where we look at ourselves again. So I'm actually feeling quite positive. I think actually it's got better because we can see mainstream media saying we need to have a discussion about this, and many of our leaders saying the same thing.
I don't know if I feel quite so optimistic, actually. I'm a university person, and I had a colleague who had quite strong views on the Treaty of Waitangi. Well, he was put under disciplinary proceedings for propagating those views, and the complaint was made by actually a non-law student. But the powers that be within the university, and here I'm actually endorsing Lord Sumption's comments earlier about universities, there was certainly not a free atmosphere, free environment for him to advance those views. And the second thing with regard to universities, you might have called back to 2018 when Don Brash was invited to speak at Massey University. He was invited by the Politics Club. Well, the Vice-Chancellor, Jan Thomas, vetoed that because she didn't much like his views and the fact that he was a member of Hobson's Choice. And so that was just an appalling denigration of free speech. And coming from a university and a university person, I mean, it's hard to actually understand. Universities meant to be the hothouse in contesting ideas. No, I mean, I'm not quite so optimistic as Deborah.
Well, I suppose what I know, I understand exactly what you're saying, and it very much alarms me, academic freedom, which I've also spoken out on. But if we look at our election, we had at least two political parties taking quite radical views on Māori-Pākehā relations. So we certainly had Winston Peters saying, I want to abolish the Waitangi Tribunal. I think that co-governance is nonsense. We had ACT saying co-governance, we don't accept it's a valid idea at all. So we did have a discussion as a country about it, and we had an opportunity to discuss it. And there was no question of anyone saying, Mr. Peters, you're not entitled to say that. So that's what I'm pointing to in terms, because I don't think we've ever had that discussion before. So in a political election, and we have managed to have that. So I point to that. I might be being rosy-coloured glasses and naive, but I think that's actually a significant step for us.
He's still, Peters was still labelled a racist for actually articulating those views by Hipkins and by the Te Māori Party.
Yes, but he took absolutely no notice.
Oh, yes, of course. Of course, it's Winston Peters.
And it's a bit difficult to call him a racist given that he's Maori.
Stephen and panel, we're about to head to afternoon tea. We just wanted to see if you had any final thoughts or closing statements for the state of free speech in our nation in regards to how it operates in a legal setting.
Could I start with Lord Sumption. Is there anything that you've been burning to add to this conversation?
It seems to me I spent most of the time between 1 and 2 this afternoon anticipating this conversation.
Would you mind going?
I've already spent 3/4 of an hour from 1 o'clock anticipating this conversation, so it seems to me that it would be indecent for me to add a postscript as well.
That's right. Lady Chambers.
Well, I really want to give my thanks to the Free Speech Union, because I think that you've become an incredibly powerful organisation in a short time, and shown the ability to change things by saying to your members, write letters, and which we do, and that makes a difference. It makes a difference. And I'm also very grateful that you brought Lord Sumption out, because I thought his speech this afternoon was superb, and I felt I learned a great deal, and I really would like a copy of it.
I just endorse Deborah's comments, actually. I really applaud the Free Speech Union. Actually, you're getting quite a powerful voice now. You're quite active, and it's to be commended. And hopefully you'll make a bit of a dent, I don't know. The forces are against you, but there we are. The other thing I was going to mention was, in fact, the Moncrief Spittal case, but I just don't think we've got time now, because I've got a few things I'd like to say about that. That was when the Peace Action Group Auckland threatened blockade of the 2 alt-right Canadian speakers. And without further investigation, the council-owned company simply cancelled the venue hire contract without going into the options available. For example, it could have gone to the police when this threat of blockade was made. There's nothing about that. I've got here Section 9 of the Policing Act, which actually identifies the functions of the police: keeping the peace, maintaining public safety, law enforcement, crime prevention. If you make a threat of unlawful action, surely that ticks all of those boxes. But no, there's no reference to the police. And also, there wasn't any attempt to actually look at their own security resources or to combine them with Axiomatic, which was the Australian company promoting the speaking tour. Several options were available, but no, McRae, on behalf of Regional Facilities Auckland Limited, simply went for the nuclear option and cancelled the event, which cancelled, in fact, the speaking engagement period. And I just want to finish by reference to the approach of His Lordship, Lord Sumption, in the Lord Carlisle decision of 2014. Where His Lordship said that, well, he emphasised the need for judicial testing in these types of cases where the question comes down to, well, is it a reasonable limitation on the guarantee of freedom of speech, etc. And His Lordship emphasised the need for the court to test, one, the soundness of the factual basis for limiting rights. Well, here there was no investigation as to the options available. So it didn't get over the line with point 1. And point 2, you must assess whether there may be less intrusive means of achieving the desired object. Well, get the police involved. So there are so many levels of that decision of the Supreme Court which were really concerning and goddamn frustrating, I can tell you that. But anyway, so the point I wanted to finish on, I wanted to mention Moncrief Spittal. Thank you.
Thank you. Thank you very much. And I want to add thanks to Philip and Jack Hodder, both men who could sell their time many times over, gave their time to that case. And when we got a sorry decision from the Court of Appeal, carried it through to the Supreme Court. And my bitter disappointment with the quality of those decisions was also partly because they had such good submissions put to them. And I thank you for that, you guys. Thank you. I won't say any more.
Well, can we give a round of applause for our panel today, and thank you for the time.